This program is brought to you by Emory University.
All right, everyone. I'd like to welcome you to a brown bag lunch presentation by Jessica Dixon Weaver, who is also our visiting scholar until November 21st, so she'll be with us for quite a while. Her office is in the third floor of the library, and I'm sure she'd love to see you and discuss the paper and anything else further if you're interested. So she's going to give her paper on child sexual victimization when abused children become neglectful mothers for us today. And after her presentation, there'll be time for some questions and some discussion. So thank you, Jessica.
Thank you. Thank you all for coming this afternoon. I'm really excited to be here at Emory as a visiting scholar, and I'm excited about my new research project, Child Sexual Victimization when Abused Children Become Neglected Mothers. So I'm not sure if all of you have had an opportunity to read the 5-page sort of thesis development that I distributed, but I'll go over some of the things from that paper and also some cases that I've had in my representation of children and parents, as well as some examination of the theories that I'd like to consider for this article. It is a work in progress. The problem of untreated sexual trauma of female children is a recurring issue in civil and criminal courts in our country. The correlation between child sexual abuse and a variety of societal maladies are well documented. The young girls who experience this type of violence usually become victims in their own homes or within their communities. These girls, who obviously grow up to be women, are encountered in several different state systems as a result of the compound life issues that they experience because of their abuse. They comprise a statistically significant portion of juvenile offenders, teenage mothers, domestic violence victims, alcohol and drug addicts, and incarcerated adults. Another place that they appear in large numbers is the child welfare system, as mothers of abused and neglected children. My research examines how the trajectory of these women's lives affects their treatment in the legal system as mothers. I'm exploring various theories that could be applied to improve the outcomes for these mothers and their children. Ultimately, it is my hope that this research will lead to a reduction in the cycle of child sexual abuse and neglect in America. Initially, I began my research in hopes of completing an empirical study on a particular thesis. My thesis was that parents who have been victims of sexual abuse or assault as children experience more trauma symptoms than parents who had not had this experience, and outcomes with their children in the child welfare system are worse. I had 3 research goals. The first was to determine if the current service plans and resources offered to parents with multiple trauma symptoms as a result of childhood sexual abuse are sufficient. The second goal was to explore an alternative interdisciplinary service plan and additional resources for these parents in order to improve family outcomes. And the third was to publish my findings in a national child welfare publication. While I still would like to conduct an empirical study after tenure, I have been encouraged by other family law scholars to use my experience in the stories from many of the cases where I've served as attorney and guardian ad litem for children as the basis for an article. After having been at Emory for 2 days, I'm convinced that the narratives of the women and children whom I served are crucial to the improvement of the child welfare system. Exploring the archives of the Feminist Legal Theory Project has been exciting, and it has motivated me to think more deeply about the story of the sexually abused female child and the role of the law as a rehabilitating process for her and her family. So how did I think of this project? There are several cases that stand out to me from my practice in the area of child welfare. I can remember an aha moment that caused me to question the connection between child sexual abuse and neglectful motherhood. It involved a young, poor white mother and her 2 children under the age of 4. She had dropped out of high school, she experimented with drugs and alcohol, and had a continual string of bad relationships from the time she was 16. She could not keep a job, and the relationship with her family was strained. When I got a copy of her psychological evaluation, I was really interested to read it because usually the psych evals tell you a lot about why the parent has been unable to raise their children in a safe environment. After reading the sentence, and I'm using a different name than what her name actually is, Sarah was molested as a child by her mother's second husband. I thought to myself, well, there it is. Here's the reason why. I then read all of the negative issues that she experienced in life after that one sentence. It dawned on me that I was making an assumption that this sexual abuse that had occurred when she was a child was the primary source of the complicated reasons that had led to the neglect of her children. It caused me to reflect on all the other mothers that I had encountered in the CPS system and their family backgrounds. I did not have to think very hard about which mothers had had a similar experience. Most of my cases seemed to have the same family history. Another clinic case where our student attorney and I represented a child or two children stands out in my mind with regard to the female abuse or sexual abuse of female children. It involved a young African American mother of two sons, a 9-year-old and a 2-year-old. They all lived with her mother, though she was away from the house more often than not. So the grandmother really was the caretaker for the two young children. After doing the math, the student and I realized that there was only an 11-year difference between the mother and her oldest child, who was 9. When my clinical student and I visited the grandmother of the children to find out the circumstances surrounding the pregnancy of her daughter at such a young age, we were told that she spent the night away at a sleepover with one of her classmates. She subsequently turned up pregnant. Incredulously, the grandmother stated that she nor her family pursued any legal action against any of the adults who were present in the home of the sleepover. It was quickly swept under the rug with the statement, "All I cared about was my daughter who was pregnant, and we had to deal with the fact that she was having a child." The mother of the boys never talked about the incident to us, although it was mentioned in her psychological evaluation. I suspected that the grandmother and the mother might not be telling the truth about the sleepover, that perhaps a family member or close friend had in fact sexually assaulted the mother and that they were covering up to protect someone. Shortly thereafter, the grandmother revealed that she suspected that her 9-year-old grandson had been molested by an adult male cousin. As mandatory reporters, we informed Child Protective Services, who then conducted a forensic interview on the child. Her grandson was unable to articulate what exactly had happened to him or who had done it. He subsequently was found by his grandmother attempting to have anal sex with his 2-year-old brother. His grandmother then began having psychological problems and sought psychiatric help in order to deal with the multiple incidents of sexual abuse that occurred to her daughter and her grandchildren. It boggled my mind that this issue of sexual abuse had worked its way through 2 generations in one family. As I have begun delving into the social science and psychological research, I've learned that the government or the state encounters these women in various different settings, at hospitals, courtrooms, public schools, mental health institutions, and social service offices. I wonder in the case with the 11-year-old mother whether the hospital inquired about the father or whether social services referred the incident to the police for investigation. Clearly, this was an instance of statutory rape. How is it that no justice was sought for this child? Moreover, what therapeutic services were offered to the child and the family, and was the utilization of these services dependent on the grandmother's cooperation? In a broader inquiry about the subject, I considered whether there is a coordinated approach in dealing with the treatment of girls who have been sexually assaulted. Is there a coordinated approach in dealing with the protection of these girls from sexual assault? In thinking about this, I recently contacted my law school roommate, who is now a district court judge in Montgomery, Montgomery County, Maryland. Prior to being appointed a judge, she was the chief prosecutor in the child abuse unit, and she also served as the chief prosecutor in the domestic violence unit at the DA's office there in Montgomery County. I asked her, did the DAs ever screen domestic violence complainants for child sexual abuse? Her answer was no, but that other agencies had statistics on this issue. When I researched the numbers, it was a bit startling, but it did confirm the research of social science scholars like Beth Ritchie, who writes about gender entrapment theory of battered women who are incarcerated. My research focuses on the nexus of the state as first responder, collector of information, and prosecutor. And I hope to propose a therapeutic solution for dealing with these girls or women at whatever stage they are found by the state. So some of the issues that I'm looking at are what exactly are the facts with regard to the numbers of children who are sexually abused. And most studies show that there's either 1 out of 4 female children who are sexually abused or 1 out of 3, which would either be 25% or 33% of our population are sexually assaulted before the age of 18. The severity ranges, but according to statistics, 15% of these children are rape victims. Um, so other child sexual abuse ranges from um, petting to oral sex to um, pornographic images or using them in porn. It's a whole host um, of things that children are exposed to or experience with regard to child molestation in a sexual nature. Studies also show that 2/3 of adults who allege child sexual abuse did not make a disclosure during childhood. So we know that children typically do not outcry. So the statistics that we get from some of the agencies that collect child abuse and neglect statistics are very low for sexual abuse, ranging from, depending on what year you look at, from 1.8% of female children to 2.9% of female children where abuse is reported to Child Protection Services, account for sexual abuse within that population of abused children. So it's very low, but that pales in comparison to the numbers of adult women who claim at later dates that they were sexually abused. So the numbers clearly don't show how dominant this issue is within women or within the female population. Interviews with adult sexual victims reveal that children who have been sexually abused by a loved one are dissuaded from reporting incidents because of increasingly severe sex offender registration laws. A victim might want to tell of the abuse, but might not because they're afraid that the disclosure will irreparably damage their relationships with family and friends, or that the offender's life will be ruined. And that has been what I've seen in cases, not necessarily related to sexual offender laws, but more related to, if I tell what happened, this person will go to jail, and this person is the person who's bringing money into the family. My mother is upset about me telling, and it usually ends up being where the child recants the statement oftentimes and tries to take it back. And they can't take it back once it's already out in the open, but because there have been studies and research on this, professionals know that this is a usual response by children. But usually they're very afraid for many reasons, because the person has told them not to tell. They will harm their family member, their dog, their sister. There's a variety of reasons why children hold this secret for many, many years. Some of the effects of the problem of child sexual abuse, as far as when these children, these female children, become mothers, are there's a wide range of what happens with regard to how they internalize what has happened to them and how it comes out in their parenting. So here are some of the effects of this type of abuse. There's usually a higher rate of teenage motherhood among children who have been sexually abused. There's a higher incidence of postpartum depression, which can affect parenting. There is a large correlation between substance abuse and children who've been sexually abused. Anywhere from 51 to 75% of substance abusing women were sexually abused as children. Typically, there's a role reversal, or what they call parentification, where the parent places more of an emphasis on the child's autonomy and reverses the role where the child is taking care of the parent. And they value the child's self-sufficiency to a greater extent. And so this skews the child's development usually, and they have somewhat unrealistic expectations of their children. And they typically fail to maintain appropriate boundaries with their children as well. Usually there's an inability to engage in intimate parent-child behaviors like changing diapers or bathing, which might lead to neglect and emotional unavailability. There's diminished communication with their children. There's increased stress related to parenting. There's typically an increase in anger or aggressiveness and the use of corporal punishment with their children. So we know from studies that approximately 33% of physical child abuse victims will abuse their children. And so women who are sexually abused are more likely to use physical discipline or methods of discipline than mothers who were not sexually abused. The perpetration of this cycle of abuse, which I talked about in one of the cases earlier, continues, and studies show that women who are sexually abused or physically abused are 3.5 times more likely to experience partner violence as adults. And so they enter into relationships where they become victims again as in domestic violence as far as being battered women. There was a 2006 study that found that it might not be the experience of sexual abuse itself that causes or that impacts as far as the mother's risk of physical abuse of her children or neglect of her children, but rather whether she was able to resolve the trauma. And the results of this study indicated that a woman's locus of control appeared to be important in this resolution. And the locus of control being, how the woman sees her ability to control her environment. The results of the study indicated that child sexual abuse was found to impact maternal depression, and that maternal depression, as well as this issue of the locus of control, impacted the risk of physical abuse. So that risk was higher where women were depressed and they didn't feel like they had any control over their life circumstances. The majority of women in this study were African American. They had a high school education or GED. They were employed. They were in lower socioeconomic as far as the status of them class-wise, and over half had never been married. And so while there have been studies that have been sort of skewed with regard to race, I haven't seen a difference with regard to race, although I can say that in practicing in the child welfare field, most of the women we encounter are women from a lower socioeconomic status. So that is the one thing they all have in common, but typically it wouldn't matter the race. They've been Hispanic, white, black, all of them seem to have higher incidences of child sexual abuse. This particular study looked at mediating variables for determining what could lower or increase the risk of abuse by these women to their children, and that included partner violence, family functioning, social support, community safety, and the level of income. So this research dovetails with findings of Kathleen Tackett-Kendall's book, Child Victimization, where it's noted that a child's vulnerability with regard to child abuse and neglect really depends on that individual child's makeup and their internal resolve to cope with negative situations. So in the studies that she has in her books, it shows that each child is not as vulnerable as the next. So some may have a predisposition to being more vulnerable and not being able to cope as well with what has happened to her. I discussed this in a previous article regarding the psychological abuse of children, where I proposed a different framework for the removal of children from parents that incorporates the mental health of children, and it analyzes the strength of the family to support the child. This idea of considering the ecosystem of a child comes from environmental science, and Professor Woodhouse was the first children's law scholar to utilize this principle within the child protection system. So this idea of an ecosystem or a child's environment, it dovetails with some of the theories that I'm looking at with regard to how can we change the system, how can we make the system work better for these women. Therapeutic jurisprudence is an approach that uses or is similar to the environmental approach as far as its applications to the child welfare system. It's referred to as TJ, stands for therapeutic jurisprudence. It's defined as the use of social science to study the extent to which a legal rule or practice promotes the psychological or physical well-being of the people it affects. There have been several scholars who have looked at this idea of TJ and applied it to the child welfare system. Susan Brooks is one person who asserts that family systems as an approach would be better than the best interest of the child. Typically, in all the cases where children are removed because of abuse and neglect, the court uses that standard in making all of its decisions. And she asserts that this, using a family systems approach, allows for the court to deal with parents and children as individuals, and it also is more rehabilitative in the sense that it takes the view that in order to understand someone, you have to view him or her in relationship to their entire family. So the idea is to think of the family as a dynamic, interconnected whole. It does, however, emphasize current family functioning rather than past history or the need for insight. And it it actually is very similar to a doctor and lawyer who I work with at SMU, who challenged me on some of my hypotheses as far as, why is it that you have to treat or you think that the core issue is this child sexual abuse? Why not just treat what's currently happening with the woman, whether it's drug abuse or domestic violence? If you treat that, then that should improve the parenting of the parent. And I would always go back to, but if you don't get to the core of why it is that she's in this relationship, or why it is that she's using these drugs or alcohol, then you don't get to, a complete rehabilitation of the mom in order to become a better parent for her child for the long haul. David Wexler is another scholar who uses the TJ method, and he thinks, which is sort of similar to something else that I've seen in the archives here at the FLT project. He talks about allowing the alleged perpetrator and the family to receive the benefits of counseling and rehabilitation, even though there might be charges of wrongdoing as far as the criminal court that may be dismissed, or they might be lessened. So in many of these cases, there's a concurrent case going on in the criminal courts and the civil courts. If the child is removed, that case is in the family court system or the juvenile court system, and the case for the father is going on in the criminal court system. And so two different DAs prosecuting based on the same or similar facts. What he's saying is that this therapeutic method of allowing the perpetrator and the family and the victim to come together can help the family move forward. And this I found to be similar to some of the things that I've read about truth and reconciliation tribunals. And so bringing victims of very serious violent actions to a place where they can talk about it in a moment of airing what has happened to them, and also bringing the person who has inflicted that pain upon them there, perhaps not at the same time, but their ability to be vulnerable at the same time and reveal how this has impacted their lives separately, and in some cases being able to come together, and the focus being forgiveness and being able to move on in your life beyond this particular trauma or incident. So this is one theory that I'm looking at as far as therapeutic jurisprudence in trying to decide whether combining psychology and the law is a better way of dealing with these women. And the thought process that I had as far as the women in the system was looking at the service plan that they are offered in the beginning of a case. Typically, in the beginning of a case, it's sort of a cookie cutter approach. The judge just checks off, okay, you need domestic violence, counseling, you need drug abuse counseling, and there's no real analysis of what's going on with the mom beyond the obvious. And it also impacts the time that she has in order to improve her life situation. And typically it's not enough time for most parents to get their act together and get their children back. So part of what I was looking at is using a different service plan or a different method of dealing with these women when they first come into the system, as long as the system knows that child sexual abuse is in her past history. They can deal with her in a different way versus blaming her as a mother or being a bad mother, because that's typically how these cases start. Another framework that I thought about originated actually from a case that I had, and it's the culpability framework. And so this idea is taking the idea of using an affirmative defense for a mother who has had sexual abuse in her past as a defense to termination of parental rights. So allowing the court to consider this as a mitigating circumstance and giving her some latitude with regard to whether her parental rights should be terminated or whether there's an alternative for her and her children. And that's not to say that the children would go back home with her, depending on what has happened, whether it's corporal punishment or neglect, but it would be something that would be taken into consideration. So I'm going to talk about a case, and I'm going to use the name Claudia, which is not the name of she was a child, but she was a parent who I represented. So Claudia was removed from her mother at 6 because of sexual abuse by her mother's boyfriend, whom the mom eventually married. She was placed with a father who physically abused her and eventually abandoned her at age 10. She was placed in foster care and she was never adopted. During foster care, she was moved maybe about 17 to 22 times. She went in and out of different homes, facilities, and institutions. And the way that foster care works oftentimes is counterintuitive to what would be best for the child. And I'll give you an example. Most children who don't have any issues are considered to be level 1 basic care. And so they would be in a regular foster home with no special services. If they have other issues that come up, they act out, they're aggressive, they have fights in school, they might have special needs in education, or they might be, they might be exhibiting other issues in their home or school. They move up in levels, so they might go up to level 2, level 3, and depending on your level, you are moved to a different home that has better treatment for you, where there might be specialized foster care parents or maybe even an institution where you can get psychological or psychiatric help. So she went back and forth between all these different institutions, and the minute that your level drops, so the minute that you start to improve and your level drops, well, then you have to be moved to a different home. So instead of remaining in the same place, she moved often because her levels would go up and down depending on what was going on in her life. She did begin physically acting out, using drugs, being truant at school, having major psychological issues. She was a runaway. She was very sexually active, and she had multiple suicide attempts. She got pregnant at 15, had the baby at 16, and her child was removed because she had marijuana in her system when the child was born. She got pregnant again at 16 and had that baby at 17, and this was during the same Child Protective Service case. So the second baby was removed because it was at risk because the first child was already in care. So even though that baby was born healthy, had no marijuana in his system, he was still removed from her. I was appointed to represent her as a teenage mom. So, my thought process in coming up with a strategy for her case was that, even though she was in the CPS system for 7 to 10 years, if you count the time that she was removed from 6 to the time of this particular case, she never did resolve the trauma of sexual abuse, physical abuse, and abandonment. She still wanted to go back home with her mom, even when I was representing her, and mom was still with the boyfriend who had, or now her husband, who had abused her. And in an ironic twist of events, that man was actually the janitor in the building where I leased space as a solo practitioner. So I knew him, even before I got the case, but after I got the case, I realized that he was that man. And so it was just a very strange position for me to be in, having to see him every day and have this case for about the length of 2 years. So this case went to a jury. We had a 6-hour jury deliberation, which is very unusual for termination of parental rights cases. Typically, juries come back in an hour or two. It's pretty clear cut, and they decide. But we had hopes, perhaps, that maybe they would come back with a result that was in favor of my client. Essentially, what I used in my strategy of in my arguments in the opening and the closing and throughout my questioning of various witnesses, including Child Protective Service workers, was Claudia really at fault for the neglect or abuse of her first child? What was the state's role in helping her to be a well-adjusted child who would eventually be able to parent? And I tried to prove that the state had failed her. And how could it then, after failing her, become a well-adjusted child so that she could parent, turn around and take away her children without giving her an opportunity to parent? And in the scheme of things, I should add that parents who test positive for marijuana are sort of the low men on the totem pole. That's like it's sort of a small issue and typically resolves in them getting their children back, all things being considered. So if she had had proper family support, and her support system was, again, the state system, then she might have been able to get her children back, but she didn't have any of that. So I used this theory of culpability from criminal law in trying to show the court or the jury at that time that her blameworthiness and punishment really depends on her attributes and the circumstances of this offense. And I think that's why it took so long for them to come back to say, okay, we are going to terminate, because essentially these were children who were very young. And if she continued, I guess, with the path of perhaps, multiple suicide attempts or continued drug use, they could see that these children might be in danger. But it was a purely these children are at risk situation, not a situation where she had battered the kids or anything had happened to them that had inhibited or caused harm to their health. Um, so in looking at, how judges or jurors could analyze a respondent mother's childhood, I would have to consider, what proof would be required um, for that mother to use the affirmative defense of childhood sexual abuse. How could this defense be considered? Because in the criminal courts, it's used in the sentencing phase. So the person has already been deemed guilty, and it's just used to determine, well, how long should the sentence be, or what should the sentence be? And in parental rights termination cases, it's either your rights are terminated or they're not. There is no sentencing phase, although this is considered to be the death penalty for parents. And the other thing I would need to consider would be the impact of the nature of services offered to the parent and the time that she had to rehabilitate. So that's the second theory I'm working with. The last theory, which I hope to really get into here while I'm at Emory, is the gender framework, because of course I am focusing on female children. The statistics do show that the number of female children that are sexually assaulted is higher than male children, although it's equally disturbing how many male children are sexually assaulted. 1 in 6 is or 1 in 7 is usually the number. I wanted to look at sort of the gender differential and whether the treatment of women when they're girls and as they become women affect their ability to regain custody. And when I looked at all the different places where the state might have a connection with a child who has a history of child sexual abuse, and thinking about in what ways do these encounters with the state have perhaps gender bias, and does this bias then significantly disadvantage them once they get into court, whether they're in court as domestic violence victims or in court as mothers who have subsequently abused or neglected their children. And when I looked at some of the other cases that I talked with you about today, I wondered whether this issue of child sexual abuse has really just been brushed under the rug because of women's acceptance of this paternalistic notion that it's the man's nature to be attracted to young girls, or this is what happens in our families, and so we just have to accept it. And I had this encounter not in my caseload, but I was actually doing some work with my church, and I have a church member here in the audience. We were doing Habitat for Humanity in South Dallas, and I was talking with one of the grandmothers in the community and telling her what I did for a living, and she said, oh, that problem is rampant here, child sexual abuse, and it kind of runs in the family. And now I see these girls who are pretending to be lesbian in order to protect themselves from being sexually molested by their cousins, uncles, fathers, brothers. And I thought to myself, wow, that's really very striking. I've never heard of that. And what does this mean for young girls growing up in this neighborhood? Are they taking on a different identity in order to protect themselves? And what is it that we can do to change this? And so she said that mothers would tell their daughters, well, it happened to me, it happened to you, and it's okay. Like, this is just what we deal with, which is very disturbing. And so that was one of the things that sort of kept me thinking about this issue and how it affects girls in particular. In my research here, I've started looking at some of the books in the archives and the books in the library about the legal issues that girls face. And they talk about this book called Lolita, which is a classic book in literature by Vladimir Nabokov, I think. I might be mispronouncing his last name. It's a story of a 12-year-old girl who is taken away by her molester who believes he's in love with her. So he actually marries the mother in order to get close to the child. And once the mother figures this out, she happens to pass away in a car accident, and then the child is left with the stepfather and is raised by the stepfather. But it's sort of this glorification of, this older man, much older man, being in love with this 12-year-old child. And I have seen that in the course of my representation as well. Men who are attracted to women because of their children, their female children, especially if they're, in their teens. There was a man who was actually a sheriff, a police officer, who was the person that sort of screens you when you come into court in our court system. There was a woman who came in to ask me what she could do about this man who she had married, who had then sexually abused her two daughters, who were 16 and I think 14. And I was just shocked because, again, another man that I see all the time. And so it's very prevalent in our communities. I looked also at Barbara Bennett Woodhouse's book, Hidden in Plain Sight. And when talking about the issue of sexual abuse, she talks about taking a secret out of a box and then putting it back in. And so this idea of compartmentalizing events is common among survivors of abuse and even wartime atrocities. But her comments actually caused me to rethink whether or not prosecution of perpetrators, years after the fact, are a good use of resources. Because always when I think about these women who are disclosing as women what happened to them as children, what is it that we do to then bring their perpetrators to justice? And sort of goes along with the swiping underneath the rug. So we hear them talk about it and we say, okay, well then let's just deal with the issues of today and not deal with that. And so in a manner of speaking, are we discounting the trauma that they experience? And so there's no resolution as to that would give them the sense of empowerment that they have control over their lives, or that something bad has happened to them, acknowledging that, and also having to hold that person accountable who is probably still in their family, that they still have to see at Thanksgiving or Christmas or their family holidays. So it's something that children deal with, in a recurring manner as they become women in their families. So those are some of the things that I'm working on as far as the gender framework, and I'm interested to hear what you all have to say, what your thoughts are about this issue, and I'll leave it open for questions and answers. Any questions? Okay.
I got a whole bunch, but I run a drug court and have run it for some time, about 11 years now. We find that an enormous number, way more than your percentages show, as to our people who were the victims. We look at it as, and I wonder about, we don't distinguish necessarily between physical and sexual abuse for our purposes. And we find that the numbers of males who have been physically abused is higher. The abuse that women as children face is more sexual. People are more willing to have sex, the sex that is bad, as opposed to with the males, they use physical violence, and they're all acts of violence.
Right.
For these folks, but to get them into treatment and to get them to start recovering, it is about addressing those issues. They have to address them. And so we don't, I don't know of any good program that tries to seek recovery that doesn't put this right out there. As soon as they get comfortable talking, you got to get them comfortable talking about those things in groups. But then you have to address it, and we use timelines, we use all kinds of techniques. What is, I guess, infuriating to me is, as a judge, I saw this over and over and over again. And it's mind-boggling. It really is mind-boggling. I would love to know what we as a system can do. We know it's there, and my numbers show that it's probably closer to 80% to 82% around. That's what our experience is in DeKalb County, of the people that are seriously addicted, who have had physical or sexual abuse in their childhood.
Yeah.
You know, I just, we try to deal with it, we have to deal with it, but as a judge, I kept seeing these things over and over and over again. The thing that was amazing to me is that there was a percentage, like you say, maybe 75%, that don't replicate it.
Right.
And I'm wondering, what in heavens happened to those people, and what can we do to try and see if we can, and you mentioned some things like support and family and
Right.
education and the things that we know about. But we have such limited resources for such a major problem.
Right. Well, one of the things that I talk about in the article where I address the psychological abuse of children, because at its core, all abuse of children is psychological abuse. I mean, it really does affect them mentally, and those are the scars that maintain throughout their lifetimes. And one of the solutions that I offer in that article is that we need to have a comprehensive sort of connection with the American Psychological Association. So the American Bar Association and the American Psychological Association need to come together, because we both know, or at least attorneys who deal with children and families, and the psychologists that deal with children and families, they know that it's a very prevalent issue in their practices. And whether or not there are adequate resources, we also know that there are not enough psychologists, not enough child psychologists, not enough family psychologists, and there's really no easy access to those people. We also have, of course, the cultural or the stigmatism of being known as crazy, in a lot of minority communities, where they don't want to go see a therapist or a psychologist because nothing's that wrong with them that they can't deal with. So it's this idea that I can just push this away or not deal with it and still move on with my life, which never ends up working out for them. But I think if we were to utilize, and there were to be a push for perhaps even more students to go into psychology, to go into this area where we have a great need for this in our community. So in the same way that we push students into math and science, we push students into psychology and psychiatric services, then perhaps we would have a larger number of people who could deal with this. But we'd have to have more money within the court system to refer these people to the services. So that's always the problem with Child Protective Services, is that they only have so much money, they can only contract with so many psychologists, and usually it's the lowest bidder, which is not the best psychologist, or the one who's going to take the most time to actually handle the situation. And so in our clinic, we actually had better results when we went outside of the CPS system, and we found nonprofits who offered children and family services, psychological, psychiatric, and therapeutic counseling, and they did a better job of dealing with this family issue than the ones that were contracted by CPS. So part of the problem, is monetary, that there's not enough money there, but then again, I also see that it has to be something that that our young people are made aware of, that this is a valuable career. We need people in this area, and we need to have sort of an interdisciplinary connection between psychologists and lawyers in the family court areas. And because we have so many specialized drug courts, like drug courts, there's domestic violence courts, they're all in those courts, and so there needs to be, what I hope to come out of this is what kind of comprehensive system, or approach can we use? Because if we screen for this, and it seems like you all did screen for it, and so the issue is there, then what kind of services are we offering to the family? And I would think that, the services may vary, because initially I thought, well, let's prosecute all these guys. If they outcry, at age 30 and this guy's still out there, let's go get him. And, I don't know that that's the best solution. It could be a solution, but especially when you think about the fact that this person might be out there still molesting children, you obviously want to protect other children from being harmed, but for that particular woman, it may not do anything for her. She may need something else. And so that's kind of, what I'm thinking of. But I'd love to talk to you more about the statistics in your court, because it's overwhelming to think of the number of women who've had this, and then to think about, well, how is it that these other women have done great? They go on, they become moms, and and they have no issues. And I just think it probably boils down to people are different. They have a different capacity to cope, and they have different environmental support systems to get them through that situation, because most of them go untreated. You had your hand up.
I wanted to ask, I'm one of the students who's going for an LLP license and doing a Juris Master here at Emory. And one of the things I encountered, and I'm wondering in your studies, how much you will look at the at-risk young ladies who are in institutions who run the risk of becoming teenage mothers who have encountered sexual abuse. Because as we talk to them and work with them, and they've done, some of them are status offenders because they won't go to school, truancies and all the various status offenses they've committed, and they're not getting the treatment that they need because one, they're charge of the court, and so the therapy and the intense treatment that they need, they're not fully getting it, but they're incarcerated. And so because of that institution, there's just this crossover consistently of these kids who get moved, and then once they've served their 30 days, they get sent back to the foster home, and so nobody ever deal with the issues that they've dealt with that caused them to start acting up in the beginning. So I'm wondering how much of your study you'll actually look at these before they become mothers or they've been victimized.
So your question makes me think about, there's a particular group that we have in Dallas County that has been focusing on girls in the juvenile delinquency system for about the past 3 years, and trying to develop a specific approach to deal with the increase of girls who they're seeing coming into the juvenile system, the increase in the types of crimes and the violence that they're committing, and again, that consistency of what's happened in their past, their family history. And so I'm very familiar with that crossover between CPS and juvenile court. Well, no, that's your kid. Well, no, that's your kid. And no, you deal with it. You get someone to handle those therapeutic services that she needs. And I think that they're still coming up with ideas of how to deal with these girls, how to get the services they need. And what they've done is really form a collaboration of different agencies. They pulled, people from Southern Methodist University, people from the public school, and so they're having to utilize resources from a lot of different places, and they've also applied for grants with Casey Family Programs in order to supply the service, the needs, or to address these needs. But still there's limitations, on what they can do with that money and how many girls actually get the benefit of that, because part of the issue also is that there are not enough beds for girls in most of these places where they need to have services. The beds are mostly for boys, or and so it's getting agencies as well as the state to understand that we need to expand the services that we have for girls, because our numbers are expanding in both juvenile detention centers for girls and also in prisons for women. The numbers are expanding, which means, and most of them are already mothers, the ones by the time they get to prison, they have a child who is left with the grandmother. I talk about that in an essay that I did in response to Beth Ritchie's gender entrapment theory about women who are incarcerated and how they're trapped or entrapped by this idea of being girls in their families, and what that means for them in raising their girls. And so it was different. She looked at both white women and black women and talked about how they were raised differently, but how both of them encountered this gender entrapment that led essentially to them committing a crime and going to prison. And so what I did was look at what happens to their children, and the fact that they're placed back in the same home with usually the mom who raised that child who's in jail. And so what does that mean for those grandchildren? Are they raised any differently? Do they encounter the same types of things? And how does this gender entrapment actually affect grandmothers? And are they in fact entrapped by the same social economic issues and the culture of violence that their daughters have been entrapped by? So it's really fascinating research, and I'm glad that you're doing the studies that you're doing, and hopefully, there's only been one school that I've seen, and there might be others, Martha, you might know of some others, that Tulane, I think, has a big push in their School of Psychology, where they offer lots of scholarships for students to go into that area with regard to child welfare and abuse and neglect and women who are battered, to get multiple types of degrees in the social sciences as well as psychology. So if we had more schools that, push that, then perhaps we'd have more people doing more research and actually being practitioners and helping women and children. So, go ahead. Hi.
Thank you for your work in this area. You know that I appreciate knowing who else is in the field doing this stuff. I wonder, with your interest in services, as you select your theoretical frameworks, if you've considered looking at trauma theories, which sort of rest somewhere in that same vein as therapeutic jurisprudence, but with kind of a dose of a developmental framework. Mm-hmm. And they've been traditionally reserved to situations of mass trauma, like major, an airplane crash or wartime, but increasingly, maybe in the last decade, have been starting to be used for a recognition among individuals, and particularly where there's been interpersonal violence. So we see it increasingly inform the policy and practice work in child welfare, like in this state, and it's starting to nationally kind of get some traction. And really, I offer that because I hear a lot of that in what we talk about, is what we're hearing through the manifestations of a childhood abuse, a trauma. What you're seeing is all the manifestations of that, right?
Right.
The subsequent inability to parent effectively, the subsequent criminality, the subsequent pregnancies, these kinds of things are about that unresolved trauma. And those trauma theories, using trauma-informed approaches, are able to have that individualized, flexible response that captures that resiliency qualities that are so individual and the coping capacities of every individual child. So they're a little bit more nimble in the way that it looks, and it really informs the service array, which is why it came to mind for me. That's maybe what you're going to be interested in finding, is how much of those services adopt that orientation. What we see in Georgia, for example, in your paper you talk about, for example, Texas, and how long it takes to detect whether there's actually been a sexual assault history or sexual abuse history. In Georgia, we actually have a pretty aggressive surveillance for that, for kids who come into our child welfare system. Okay. It's driven a lot by things like litigation, consent decrees, and all manner of things. But we we assess kids within 30 days with comprehensive assessments. Frankly, what we learned over time is that there's a trade-off for that if you're surveilling for that and you're diagnosing that, you're finding it. That's good by way of reporting, but if the response, you can almost start to kind of put kids in those molds and have them sort of take on these appearances of victim when they've otherwise been more resilient and they don't need all of that kind of intervention. And it very much starts to look like assembly line kind of triage. So the trauma-informed approach is sort of coming to light mostly because of the attention that people are placing on medications for kids. Yeah. A lot of it coming out of that area. Yeah. But there's starting to be a reorientation in Georgia where our providers who would have otherwise done those 30-day comprehensive assessments are now required to do trauma assessments on kids. And based on the indications that come from those trauma assessments, will determine what other kinds of evaluations and services are to be offered to that child. So it no longer looks like every child gets a 30-day psychological and so on, but a little bit more customized to the children. So that's kind of what came to mind, and I know you've got some theories selected.
Yeah, no, that's good. And I was thinking about, and so in the trauma theories that you're talking about, and I'm making a guess as far as, because I've seen this before, sort of treating this trauma as they do post-traumatic stress disorder. Exactly right. So yeah, as far as, and that would be a more individualized process versus the sort of cookie cutter or assembly line that you're talking about, because one of the things that I did with the psychologist that I was working with at SMU was we looked at the risk assessment that they give, or that the CPS caseworker does with the parent. So when the child is removed, they sit down with the parent and they ask all these questions, and then they go back and fill out the risk assessment. So one of the questions on the risk assessment is, is there a history of abuse or neglect in this family? And so, yes. And then they say explain later. And so, there's a part where they can explain, but they don't specifically ask about whether it's sexual abuse or physical abuse. It's sort of up to whatever the parent discloses, with that general answer as to what they are able to put down. So sometimes it's captured and sometimes it's not. And so I like the fact that Georgia is aggressive, but then there's that opposite end of it, because thinking about how many women end up in the child welfare system as mothers who may have had children, very young, and there's this history of child sexual abuse. Um, it does appear to be sort of an assembly line of, okay, let's just throw these services at them and see if they can manage to get it all together within a year's time and get their kid back. So yes, that would be very helpful for me to look at more.
Assault, something intimate, right?
Right.
About that's not as true about a physical assault, or as true about even a chronic neglectful situation.
Right.
That sort of pronounces the trauma. And I'm kind of interested in that factor too.
Yeah, I've seen that in some of the studies that they show as far as what are the effects of this on mothers, and why is it such a intimate, why is it such a lifetime, there's a lifetime of these effects that occur, as opposed to excessive corporal punishment, and some other forms of neglect that may not be so invasive. And my instinct, and from what I know from practice, I would say that there's much more of a deeper psychological effect that that children have who are sexually abused, because on top of the physical violence that has happened to them, which many of them don't understand at the time it's happening to them, there's this psychology that sort of beat into them, like, don't tell, and if you tell, and they're having to hold together the family with this one secret, and so they know that if it comes out, everything will fall apart, and so that's a lot of pressure for the child to hold on to for a long period of time. So I think it's sort of it's definitely more psychologically damaging. I don't know whether the studies would show that, but it would seem like the effects definitely sort of live that out for women. There was a hand over here. Two hands. Okay, good.
Hey, thank you. A very interesting approach. I had two questions for you. The first is, it sounds like your focus is on a affirmative defense at the trial level. I'm wondering if you've looked at all about whether or not you would consider making this an exception to the law, so an exception to the Adoption and Safe Family Act time requirements for filing for termination of parental rights, rather than leaving it to be raised at the individual trial level. And if that is the approach, I'm just thinking of balancing that with the child's need for stability that ASFA is really aiming for, and do we have a sense of how long this treatment takes?
Yeah.
If it's longer than the usual time frame for TPR, how much longer? What does that look like, and how do we balance that with the child's need for permanency and stability? The second question is around this question of offender accountability. It seems like there's a pretty good body of research that indicates that a lot of the people who abuse children sexually have been sexually abused themselves.
Mm-hmm.
And so I'm wondering about sort of increased compassion and understanding for mothers in the child welfare system, but not showing that same increased compassion and understanding for the offenders, and whether or not there's a way in our accountability model on the offender side to take into account trauma that led to offender behavior, and how we balance that.
Yeah, great comments. So yes, I have considered this issue of sort of the exception to the ASFA timeline, and definitely gotten feedback with regard to, well, what about the children's timeline, and how much longer would you allow mom to try to avail herself of services, and how long would that take? And there's no, one answer. Like, it might take 6 months longer, it might take a year longer. But when I thought about it, I thought, well, at least, not file termination proceedings for 18 months, because it takes a while to even assess things and get her into some form of treatment. And then depending on that treatment, your idea about, some compassion towards perpetrators, oftentimes that person is still in their neighborhood, still in their circle that they see, if they haven't gone to jail for something else, or they might still be, in their family as stepdad or whatever. And so there is a need for some type of therapeutic approach, and David Wexler's approach with regard to therapeutic jurisprudence and sort of allowing the family to come back together makes me think about collaborative law and sort of family group conferencing and that type of thing. But it is I hesitate to think of that notion because I think, well, what about that adult woman who was the child being put back in the situation of having to confront this person and what that might mean to her as far as reliving that, making her situation worse, and then her taking longer to get back to the point where she can become a mom or be a mom safely to her children. So as I continue to research, I feel like this individualized approach is necessary, sort of figuring out what are the strengths of the family. You know, does she have support there to, if she were to go through this therapeutic process that would involve the perpetrator, do the other people in her family believe this happened and support her as opposed to him? And then the idea of, well, maybe his perpetrator is lingering out there too. It was grandpa or grandma or whoever. And it's very mind-boggling to think of how in the ecosystem of their family it comes down, you know, the tree as far as this issue of child sexual abuse. But I do think it would be helpful to move forward for women to have some additional amount of time. It's very difficult for me to say what that is because I've been both a representative for parents and also children. My heart is with children, and so of course I'm thinking, well, 2 years for them is a really long time. And I think it would probably work better if they were placed with relatives, which the majority of kids are placed with relatives. So if there's a supportive relative who could be a guardian or managing conservator for that child during that time where they had more active visitation with the parent, or even if the parent, because we have some other types of systems, and I'm sure you all have them here in Georgia, where the children are not really removed from parent, but they are they have to live with someone else, or they have to have some other support around them in order to sort of actively protect the children from any kind of harm. And so they enter into this process where the whole family gets treatment, the grandparent or whoever the support is for the mom. But again, we're talking about more resources, and that would mean that we'd have to look at this in a much more comprehensive way and in an individualized way. So I probably would argue for, if I were to change the ASPA timeline for a case-by-case basis, which means that our judges would have to be trained on that in order to make the assessment. So there are some moms who might not ever get it together, and should that mean that the child languishes? No. You know, that means that they need to move on and come to some closure and still provide mom services, because 9 times out of 10 it's a young mom and she's going to have more kids. And so that just means that they go back into the child welfare system again. So I'm not saying don't provide services to the parent, but I think there needs to be a proper balance there. And the only way you can figure that out is to sort of assess what are the strengths and weaknesses of this family, and how can they support this child. In the article that I did on the psychological abuse of children, I talked about how I thought that the focus on the best interest of the children is sometimes off-center, because I feel like the primary concern should be the strengths of the family and how the family can better serve that child. So whereas you have these separate services, usually therapy for mom, therapy for kids, but in no way do they all come together, you know, before they return back home. And it doesn't make sense. You know, there's not sort of the development of a family dynamic or a post-removal way that they operate. And I think that should be more of the focus of the court systems that deal with these types of cases. There's another question. Are we out of time?
No, we were out. One,
Okay.
if you don't mind just waiting in
Sure.
in more informal discussion, but I want to thank you very much for a very interesting presentation.
Thank you.